So I would like to welcome everybody to this Global Congress session, Pandemic-Proof Libraries, Lessons from COVID-19. My name is Teresa Hackett. I am the moderator of this session. I work for an international NGO called EIFL, Electronic Information for Libraries, that works with libraries in developing and transition economy countries. I manage the program on copyright and libraries. So in our session today, we're going to have short presentations by 6 great panelists from around the world who bring together with them a wealth of knowledge and practical experience from a legal and a policy and a library perspective. There will be an opportunity to ask questions and to make comments, and that's down in the Q&A button at the bottom of your screen. So feel free to post any comments or questions during the session, and Camille and I will be keeping an eye on the questions. We do welcome contributions from different countries and different regions because we would love to hear your experiences and any initiatives that you have you're doing in this area, because the issues we're discussing are really all global. So we have 80 minutes for our session, and it's a hard stop. So the organizers have told us that they'll terminate the session 3 minutes after the end of our allocated time. So we have to be strict. We will be strict on our time, but I hope that we'll have a good panel session and a good discussion as well. So just to introduce the session, yesterday at the Global Congress that started on Monday, there were a number of sessions that touched on the issues that we'll be discussing further today. So if you didn't have time to check in or to follow those sessions, I recommend that you take a look. I'm sure they'll be available afterwards. So there was a session on WIPO, the World Intellectual Property Organization. There was a session on controlled digital lending, and there was also a session on education exceptions that mentioned, actually Paul mentioned the statement from Guelph that you'll be talking about later. And the context for this session, and indeed the theme of the Global Congress this year, is that at the end of March in 2020, earlier in the year, 1.5 billion learners in 193 countries were affected by either national or local closures of schools and educational establishments. And these changes, as we know, they happened very quickly, overnight and midway through the academic year, leaving teachers and students and librarians with no time to prepare. So for education to continue, it had to move online and off campus. And one of the key challenges for librarians is that the rules for the use of copyright protected material for online teaching and use are often different from the rules for face-to-face teaching. So the first task was to assess the impact of the new situation according to the copyright law or the licenses for the electronic resources to which the libraries had subscriptions. And this was to support teachers and students at in this difficult time. So our session today will be structured into 3 parts. Loosely structured into 3 parts. We'll talk about the licensing issues, we'll talk about some copyright issues, and then we'll talk about the international environment. So in terms of licensing, I think 2 issues emerged pretty quickly. The first one was that restrictions on the use of electronic resources in licenses didn't always accommodate this new situation that we all found ourselves in. So for example, there were limits, there may have been limits on the number of simultaneous users that could access the resources. There were restrictions on off-site remote access that was now needed and was essential in March. And so at the start of the pandemic, ICOC, the International Coalition of Library Consortia, issued a statement asking publishers to lift these restrictions on a temporary basis. So for example, to waive user limits, to lift restrictions on interlibrary loan or photocopy limits. And I think very importantly, in the context of our talk today, is to allow the use of all copyright exceptions in your national law, even if restricted by the license. Now, publishers responded by expanding access and easing these restrictions, and libraries are very grateful for this temporary relief that was offered. But I think it shows two things. One, it shows the extent of these routine restrictions that are in the licenses that libraries sign with publishers. And the second, and the question that has arose is that, like, should we have to rely on the goodwill or the kindness of individual publishers to deliver on the fundamental right to education, especially in times of crisis? So that's a question is being discussed. The second issue that came up in the context of licensing is that reasonably priced and widely available ebooks would help alleviate the pandemic situation when library access is restricted, so the access to the physical buildings are restricted, or when there are fewer print copies in circulation because of the need to quarantine the books that come back to the library. So you have books that need to be quarantined for maybe 48 hours or 72 hours. So that means you've got fewer print copies in circulation. So our first two speakers will address this issue of textbooks. And then looking at the copyright issues, the question is, how do our copyright laws shape up in the pandemic? And are they a help or are they a hindrance? Well, copyright librarians were busy analysing their copyright laws in many countries, looking at the laws, looking at the exceptions. Do we have an exception to the communication to the public right or the making available right? Can we do this? So there were many, there's been a lot of discussion about national copyright laws. And of course, some copyright laws are better equipped than others. So we'll look at two countries, the US and South Africa, to see how library activities have fared in their law. And then Camille from IFLA will do a brief roundup of other interesting things that are happening, that are going on in this general space. And then from the international perspective, there have been a number of responses from the community and from governments proposing a range of voluntary and regulatory measures. And I'll just give a couple of short examples. From the community, we've had, for example, in Europe, LIBER, the Association of Research Libraries, called on the European Commission and its member states for a public interest defence for research and education and libraries in terms of crisis, such as COVID-19. Also in Europe, Communia put forward the case that the basic rights enshrined in the EU Charter on Fundamental Rights, such as the right to science and the right to education, should be applied as a break on exclusive right in exceptional situations. And in the US, library copyright specialist reaffirmed the role of fair use supporting remote teaching and research. And there have also been a number of initiatives from governments. So 15 major countries asked scientific journals to make their COVID-19 publications and data immediately accessible to support public health. So the countries included Australia, Canada, Germany, India, Japan, Singapore, UK, US, and the European Commission. And in April, the government of Hungary issued a new decree easing copyright rules for online use of works for education in an emergency. As far as I know, that's the only government that has made that specific measure, put a specific measure in place directly as a result of the pandemic. Then at the international level, a civil society coalition, including IFL and IFLA and a number of other of our panelists who are on the call today, called on WIPO, the World Intellectual Property Organization, which is the body that sets global copyright laws, to take a stand so that IP systems are a support in the fight against the pandemic. And WIPO have launched some new tools, IP tools on COVID and COVID and copyright, and they also issued a policy statement. And our final speaker, Luis, will frame some of these issues from an international perspective, looking at maybe how the treaties can support libraries in the pandemic and where should we go from here. So I hope that you enjoy the session, and I think, as I said, we're going to hear some interesting presentations. And with that, now I would like to hand over to our first speaker, who is Paul St. Pierre from the University of Guelph in Ontario in Canada. Paul is the Collections and Content Librarian for Sciences, and in the pandemic has been closely involved with the textbook issue. So Paul, the floor is yours. Thank you.
Thank you, and good morning, everyone. I'm still getting used to Zoom conferences. Let me try and share my slides, share screen, and okay. So we're at the University of Guelph, which is in southern Canada. We're a medium-sized university, about 30,000 students, and we're a comprehensive research university. I will say I was not the lead on this project, and I should give due credit to Heather Martin, our manager e-learning and reserves, who's been on the hot seat this year, and Ali Versluis, our open educational resources librarian, whose job is really to promote the adoption of open educational resources on campus. Our three collections librarians, we've been sort of the backstop in trying to find licenses for difficult content. And I was tapped to present today. So moving right along, if I'm able to forward my slides. So we wrote a post that seems to have gotten us a little Twitter famous, called Commercial Textbooks Present Challenges in a Virtual Environment. And there's really 5 points that I want to make in my 7 minutes that I have remaining. Textbooks are too expensive. That's pretty obvious to everyone. I'll talk briefly about the publisher problem that Teresa's already gone into some of that material. I'll also mention the professor problem. So it takes a community to create a problem. It takes a community to solve the problem. I'll follow up with our action, what we did, and how people reacted to that. So in 2016, the University of Guelph conducted a survey of students. And this survey was a result of a collaboration between the VP academic at the university, the library, and the undergraduate student body. Not surprisingly, respondents said that affordability or unaffordability of textbooks had various negative consequences for them, whether it was stress or grades or forcing them into infringing behavior that they didn't want to do. So I won't go into details on that. We all know that textbooks are a problem. And the outcomes of this survey were really a three-part. Our reserves team decided that they would buy a print copy of every required undergraduate textbook. And they had a budget of around $40,000 US to make this happen. That worked okay for a while, but of course the pandemic put an end to print reserves for the most part. We also ended up creating a new position, an OER librarian position. And this was really to recognize that it was a longer term struggle that we needed to promote the use of OER as well as promote the creation of OER. And that's what Ali has been doing. And she is also been on Twitter communicating and spreading the gospel of OER, as it were. And thirdly, this led us to increase our investment in open infrastructure. So Pressbooks is an e-textbook publishing platform that we subscribe to. And this emerged in addition to our open journals support and various other types of support for open research. So these three outcomes were quite positive from the survey. So the publisher problem, of course, the e-textbook distributors circumvent libraries. They don't want to sell us licenses to their books. I've said to professors, the publishers simply will not do business with us. They want to sell 300 copies of their textbook to your students and none to the library. And not just regular textbooks, but sometimes when a certain text is adopted to a lot of courses, the publisher will then create limitations on what can be licensed. They'll either reduce the number of simultaneous users available, or they'll jack up the prices. In some instances, we see $1,000 for a single user license is what's made available to libraries. And professors are quite shocked by that. So is everybody else. And unfortunately, sometimes our reserves team ends up buying multiple single user licenses for a work, or multiple 3-user licenses. Now, they typically wouldn't do that for $1,000 title, but the numbers add up very quickly. I won't go into detail, but we're a research university. So we have this tension between building a research collection and building a textbook collection. So this is something that is always a challenge, limited resources to go around. And of course, we have the publisher problem. I'm shocked to often see new courses being proposed that make no use of the local library collection. Often professors don't even bother seeking available resources in the library. In the sciences, we primarily buy books in electronic format now. So they're missing out on a lot of available resources quite often. They assume that e-textbooks are just as readily available to libraries as they are to students. Often I'll get a message from a professor saying, oh, it's available on Kindle, so why doesn't the library buy a copy? It's like, well, we don't buy Kindle editions. They're not available to us. And they don't understand that the institutional licenses are much different than personal licenses. And of course, professors who are not interested in the commercial textbook market don't really understand it very well. And sometimes they get angry at the library for refusing to comply with their wishes, whereas in reality, we're just simply unable to. And of course, little understanding of copyright. And this is not universally true, of course, but they often don't consider the cost to students that textbooks entail. Okay, so we a web post, a simple web posting that we didn't think would be a big hit, trying to communicate with our faculty in particular that explaining the publisher problem to them. Faculty are stressed and frustrated, but so are librarians. And so this was one of the ways that we wanted to reach out to instructors and let them know that we were struggling to assist them. Now, one of the things we did is we actually named the worst offending publishers. So we named names. We had a bit of a debate as to whether we should be so explicit in mentioning them. And we decided to just go ahead with it. And this turned out to be very popular with librarians, very unpopular with publishers. Now, not only did we name publishers, but we wanted to suggest alternatives that instructors could use. The three main suggestions we made was to use existing works in the library collection. As a collections librarian, I always want our collection to be better used. Our reserves team builds course packs, not traditional course packs that students purchase from the bookstores, but using our online learning platform, combining already licensed resources, fair dealing or fair use, freely available open access resources, and when necessary, getting copyright clearance for chapters and articles. And then finally, also another alternative is promoting open educational resources. So it was really a problem that we turned into a self-promotional opportunity for the library. And the reactions were really quite strong. Librarians reacted very strongly to the message and adapted it locally. So clearly, and we did this in June. So this was just as the free access was being shut off, and the problem for the fall semester was looming large for everyone. So lots of libraries have readapted our text around the world. It's been translated into at least French, as far as I know. It's opened more conversations about textbook affordability, both within the university and beyond. I had a phone call from one of the publishers, from one of the very large publishers, who wasn't very happy to be on our list, but understood the reason for it. And she was quite positive in our conversation that we were looking at ways that it's a problem for our users and what the publishers can do in response. It also, of course, strengthens our arguments for open educational resources. If we can't depend on publishers to provide affordable and accessible content, then we're going to have to do it ourselves. And it really brings up the need for librarians to engage with instructors in selecting readings. We have great collections that are already available, and we have a strong interest in providing access to all of our students. So working with instructors, I think, is one way to really get away from the textbook publishers. And yes, so I think that that's really a key note for librarians is if copyrighted material is not going to be made available, then we have to find alternatives. And we have to use our expertise with copyright and licensing to negotiate with faculty who don't have those skills. And I believe that is all I wanted to say. I have a couple of links here to our textbook survey results, as well as the post that we made in June. And that's all I have to say for now. I'm happy to take questions in the discussion part of the session.
Okay, well, thank you very much, Paul. That was a very, very clear overview, and I think also raised some of the wider issues and the context for this discussion as well in a university. So thank you very much. And now we're going to hand over to, we're going to cross to the other side of the Atlantic and talk to Caroline Ball from the University of Derby in the UK. Caroline is a subject librarian in Derby, supporting law, criminology, policing, international relations and sociology programs. She's also the university's copyright and licensing advisor. And I just read today that Caroline has been awarded, she's the Wikipedian of the Year in the UK for 2020. So congratulations on that, Caroline. But in the pandemic, Caroline has been involved in a UK campaign to investigate the academic ebook market. Caroline, over to you. Thank you.
Thank you very much. Yes, I think it's quite interesting listening to what Paul was saying just there, because I feel like what we're doing in the UK is really the next step, effectively, in that we are struggling with the same issues, precisely the same issues about how do we make material available to our students. I think this is something that has been an issue for quite a long time, really. This is not something that is new to our current situation, but I think the current situation with COVID, with so many libraries being closed or having restricted access and having to rely so especially on our electronic resources, has really brought this issue to a head, really. So what we are doing in the UK at the moment is we have an open letter that has been drafted. It's been kind of kicked off really by Joanna Anderson from the University of Gloucestershire and Rachel Bickley from London Metropolitan University. And I think basically it was a we're mad as hell and we're not going to take it anymore kind of moment. I think we've had these same issues that Paul have. We've been looking at, you know, what can we do about alternatives? How can we make our academics and instructors use material that we do have access to? But there is a, a very serious pedagogic issue there about not allowing academics to use the material that they want and they need simply because it isn't available. And it isn't available because of a real decision taken by publishers to not make it available. And I think that's the key kind of issue about this whole campaign, is that it is not that the material doesn't exist. It is not that it is totally inaccessible in that sense. It is publishers are choosing not to make it available to libraries, or they are making it available at prices that are so extortionate that libraries can't afford to buy this material. And that's a real decision being taken by the publishers. And, even under normal circumstances, that was an immense frustration. But I think now it's almost getting to the point where libraries feel like we are being held to ransom. We are desperate to get this material in electronic format, and we simply can't, because now we cannot rely on our print holdings to fill in the gaps, whereas previously we might not have bought ebooks that were available because we couldn't afford to, or where ebooks weren't available at all. Previously we would go, okay, fair enough, and we would go and buy maybe more copies of the print books. But now, with access to our libraries being restricted, with the need to quarantine items after they've been used, it is really, really vital that we try and make material accessible electronically. And increasingly, that's where we're finding that our hands are tied by the publishers. Just as Paul has found, many ebooks are simply not available because publishers have decided that it isn't in their cost benefit to make them available to libraries. They prefer to sell directly to students. Some ebooks are only available in packages. So, it's a case of, yes, of course, you can have this ebook. You've just got to buy these 100 others that you don't really need. Some are only available on bespoke subscription platforms. So I'm thinking in my own areas of things like Law Trove, to get OUP, Oxford University Press law textbooks. They are only available on Law Trove and only by subscription. Some books are only available via the e-textbook model, so on platforms like Cortext or VitalSource. And those that are available on what we call aggregate platforms are often exceptionally and unreasonably expensive, as Paul was referring to there. It's not uncommon to see instances where ebooks are, 1,000 times more expensive than a print book. I think recently on Twitter, I saw a librarian sharing possibly the most extreme example I've ever seen, which was for a book from Wiley Blackwell. I will name names and shame, just as Paul has been. It was a book called Hofbrand's Essential Hematology. We'll see how essential it is. It was a single user license for 1 year. And it was, well, I'll say, first of all, the print was £50. The ebook was £99,999.90. So just 10 pence shy of £100,000 for a single user access ebook for 1 year. And, when you hear stories like that, it just absolutely enrages you. And the argument that publishers make is that they're making up for lost sales, that obviously if the students can all go to the library and use the ebook, they aren't going out and buying the print copies. It's a fallacious argument, because by that logic, then a single user ebook should cost the same as a print book, which is still a single user item. Only one person can borrow a book at a time. But, that's the argument that they make, that they are making up for those lost sales. Now, it's an argument that's been thoroughly discredited when it comes to things like film and music piracy. Someone taking advantage of something that's available to them for free does not mean that they might otherwise have gone out and bought that item. So we feel that, if it doesn't hold true for music piracy and it doesn't hold true for film piracy, it doesn't hold true for our ebooks either. An academic ebook made available by a library does not eat into print sales. It does not mean that students would have gone out and bought those ebooks. And obviously we don't have an issue with publishers making a profit. It's an industry, they have a right to make a profit. But what we're talking about here is profiteering. There is absolutely no justification for some of the pricing that we are seeing here. And this is a case where some of these prices have gone up since the COVID emergency, where publishers are absolutely taking advantage of this current situation to hike prices because they know that universities can't make this material available any other way. And that's really what's kind of kickstarted this campaign. So what we have is an open letter that is currently circulating mostly on Twitter, and being signed by librarians, lecturers, students, researchers, archivists, and it is addressed to the chair of the Education Select Committee in the UK Parliament, basically calling for an inquiry into the practices of the academic publishing industry, calling for an inquiry into how this is allowed to continue, how this is allowed to happen. You know, it's a particular issue, I think, in the UK at the moment, because there is a lot of agitation on the part of students about the fees that they're paying, about what they are paying for, about the service that they're getting. And it really brings it home to some students when you tell them your £9,000 a year is paying for 5 or 6 ebooks. The money that you are paying is going into the pockets of these big multinational publishers who are holding this material to ransom effectively. Academic publishing is basically an oligopoly. You have these massive publishers with many imprints underneath them. So it's not like there's always alternatives for some of these texts. It's not like you can always go and shop around. You know, if you need a particular ebook, you need that book. And sometimes these publishers, you know, the prices that we're being asked to pay, particularly in an era now when budgets are under so much pressure, is meaning that kind of educational and scholarly and research material is just locked away. It's just completely inaccessible. And I think the current situation and the way that the academic and research community kind of opened up all research around COVID, you know, made material available, didn't allow it to be locked away behind paywalls, really demonstrates how much the whole world benefits when access to that kind of vital information is available. So this campaign is really designed to try and raise awareness of this issue. As Paul was mentioning there, you know, even within our own communities, many people are not aware of these issues. Academics are not aware of these issues. And I think librarians, traditionally, we're very good at kind of make, do and mend. We don't tend to you know, kick over the traces. We don't tend to make a huge fuss. We do tend to just get on with things. And I think we've got to the point now where librarians are really being pushed too far when it comes to ebooks, where we feel like we are being taken advantage of, where the prices are just getting higher and higher, and increasingly we cannot make material available to our users. And that's the point that we've got to. We're here really in the UK, where we're asking our government to now pay attention to this issue, because it has enormous knock-on effects to students, to academics, to research, to education. You know, this is not just a niche little library issue. It is much bigger than that. So we are effectively starting to fight back, or trying to at the moment. So we're still gathering signatures to this open letter at the moment, and then I think the end of next week it's going to be delivered to the chair of the Education Select Committee, and hopefully we might see something happening. So I'll just share my screen with you so you can actually see the website if I can. I'm not sure if it's going to. No, I don't think it wants to. But the web address for it is academicebookinvestigation.org, if anyone is interested in looking at it. The text of the letter is completely open. So if anyone is interested in trying to kickstart a similar campaign in your own country, I think we would really welcome that. And I think the more that we can, you know, join hands across borders and make people aware that this is not just a parochial issue. This is not just a UK issue or a Canadian issue. This is a global issue, because these are global publishers. I think that the more impact this can have. So we're really keen to work with others, with other countries who are looking at trying to get a similar investigation going, because I think if we can, you know, broaden the scope of this and make people more aware of it, it's only going to have more impact. So I'm ranting a bit. Anyone who knows me will know I can rant for England on this topic because I get so angry about it.
Well, thanks so much, Caroline. And I think that was really a really interesting rant. We put the link to the open letter into the chat, so it should be available for everyone there. And I think remarkable similarity between the two issues, between the issues in both countries. So it's not a national issue. It really is a global issue affecting all institutions that need access to this material. I encourage if any of our participants have any questions, please type your questions into the Q&A, and we'll be glad to take them up at the end of the session. So with that now, we're going to shift slightly from the licensing to the copyright side to see what supports and how does copyright law, how has that supported or provided assistance to libraries in the COVID times. Our first speaker is Jonathan Band. Jonathan is adjunct professor at Georgetown Law in Washington, DC. Jonathan is a copyright lawyer known to many of you, I think, with experience working with libraries, archives and education, helping to shape copyright law and policy worldwide. And Jonathan will address in particular the issue of fair use in US law. So Jonathan, over to you.
Thank you very much, Teresa, and thanks to everyone for joining this panel. So U.S. libraries have had the same licensing issues that the previous speakers indicated, and not surprisingly, we're dealing with the same language, English, same publishers, and so the challenges are all the same. One advantage the U.S. libraries have had in adjusting to the pandemic, and this is the academic libraries, is fair use. Now, of course, that exists in Canada in a very similar form, but not of course in the UK and elsewhere. There it's fair dealing, but it's more limited. So in particular, one of the things that has helped libraries, academic libraries, continue to serve their research function, at least during the pandemic, is the seeds were planted more than a decade ago in the Google Books project. And so Google Books project was this huge digitization project. It led to the creation of the HathiTrust Digital Library, which is a consortium of probably over 100 libraries by now that have this database of 15 million, 20 million, who knows how many volumes of books. And these are scans of all the books in the collections of all these libraries. Now, until now, the access has been relatively limited, the access to full text. So you could do text and data mining, but if you wanted to see full text, the full text was really only available to people with print disabilities. And all this is done under fair use, and there was some litigation, most notably the HathiTrust, the Authors Guild versus HathiTrust case that found that it was fair use for HathiTrust to operate this huge database, the HathiTrust Digital Library. It was fair use for them to provide this text and data mining availability, and it was fair use for it to provide full text to people with print disabilities. But HathiTrust was very careful not to provide full text beyond that scope, beyond people with print disabilities, because that seemed to be probably crossing a line beyond what was permitted by fair use. So along comes the pandemic, and you no longer could access the libraries. And so what HathiTrust did is it started the Emergency Temporary Access Program. And under that program, it's basically what many people refer to also as controlled digital lending. It will allow a given library, let's say if a given library contributed, or has in its collection, let's say 500,000 books that are in the HathiTrust Digital Library, then HathiTrust would make available to that institution the text of those books, so that students or faculty, authorized users from that institution could access those books. Now, not other books that aren't part of that library's collections, that they can't get the access to full text. It's just it's the students and faculty at that institution could get sort of the equivalent of if they were able to walk down the street into the library. And so it was the books that were in that library. And also they maintained an owned to loan ratio so that if it was one book that the library had one book in its physical collection, then only one user at a time from that institution would be able to access that book. And so that has gone pretty well. As far as I know, that hasn't seemed to cause any problems. It doesn't seem to have really caused publishers much heartburn. You know, we haven't heard complaints, at least not publicly. And I think they're planning on continuing that sort of for the duration of the pandemic, as long as libraries are closed or campuses are closed, and or there's restricted access to these collections. And again, that's all done under a fair use theory. And so kind of the expanding access was saying, well, okay, we're in a pandemic. Again, these are books that already were digitized, and we're just providing access to those books. So there's no harm to the market. Now, you may have heard more about the lawsuit involving the Internet Archive. Now that's different. That's something different from what I'm describing. It's different from the HathiTrust Emergency Temporary Access Program. So the Internet Archive has had this open library program going on now for nearly a decade. They have over 1 million volumes available in their open archive. They also, the open library has been operating under a sort of more traditional own to loan controlled digital lending. So you could only, if only 2 books, 2 titles, 2 copies of a particular title had been donated to the Internet Archive, they would only loan out 2 at a time digitally. During the pandemic, they turned on what they called the National Emergency Library, under which they basically, you know, they say the way they describe it is they suspended the waiting list. So in other words, books, they suspended the owned to loan ratio, and so that they would lend out an unlimited number of copies of any given title. And so the theory being that all the public libraries and all the academic libraries in the country were closed, and so you know, all those users would otherwise be able to go to the libraries to access the books. Now those books weren't available, so they would be they were available without a wait list from the Internet Access National Emergency Library. They had some restrictions. They tried to exclude more recent titles. So this was basically, you know, books that were 5 years and older, but some more recent titles were included. It was not, unlike the HathiTrust Emergency Temporary Access Program, which was academic libraries and, you know, mainly monographs and all of that, you know, truly academic books. The National Emergency Library had a lot more popular titles, trade books and so forth. It sort of was a mix of whatever had been donated to the Internet Archive's open library program. The publishers complained very loudly about that, as did authors groups such as the Authors Guild, and then, in fact, the lawsuit was filed. Now, the Internet Archive had announced when they started the program, they said, well, we'll probably end it at around June 30th. You know, hopefully things will start easing up by then in terms of the pandemic, and also other approaches, maybe publishers will ease up and make more things available. And so the lawsuit was filed sort of in early June. Internet Archive suspended the National Emergency Library about a week or 2 earlier than they otherwise would have. We all hope that at that point, once they turned off the the National Emergency Library, the publishers would drop the suit, basically declare victory and go home. But they have persisted. They're still seeking damages for the National Emergency Library, even though it doesn't appear that it really was all that heavily used. And also they're pursuing the open library, so the pre-existing program, which makes works available on an own-to-loan basis, not just sort of on the unlimited basis of the National Emergency Library. And so that aspect of the lawsuit is really troubling to the library community, because not only does it sort of get into what the HathiTrust is doing with the emergency temporary access, but many other libraries are considering controlled digital lending in one form or another, for certain subsets of their collections. So we'll have to see what happens. There's a discovery plan, and that litigation seems to be going forward, and it could, litigation in the United States takes a long time. So that could really be very long in its going forward. And again, the publishers really seem to be, set on seeing this through. So in any event, those are the two big programs that have been underway under fair use, and I'll stop there. Thank you.
Okay, thanks, Jonathan, for that overview of the situation in the US. And now we're going to go south to South Africa, and we will welcome Denise Nicholson to tell us about what's happening in your part of the world. Denise.
Good afternoon, everyone. I'm going to read my presentation because of the short time I have, but thank you very much for the opportunity to speak to you about the situation of copyright in South Africa, which is a developing country in transformation. The COVID-19 pandemic has highlighted the long-known inadequacies and restrictions in our current copyright law that negatively affect access to information, knowledge sharing, and the provision of relevant teaching and research materials in our educational institutions. Our current law is 42 years old, totally outdated, with fair dealing and limited exceptions for education, libraries, and archives. It has no exceptions for people with disabilities and does not address the digital environment at all. On the 27th of March this year, South Africa went into level 5 lockdown in terms of COVID protocols. Libraries, archives, museums, educational institutions, as well as bookstores and most businesses were closed at a very short notice. University residences were swiftly evacuated, resulting in many students having to leave their residence rooms and leave their textbooks in their rooms before they left campus. Access to hard copy material, multimedia and archival collections in libraries and archives was obviously totally closed off. And even now in level 1, some libraries are still closed or partially closed. Overnight, e-learning platforms became the virtual classroom for schools and tertiary institutions. Suddenly, institutions had to find funding to assist students with training, software, hardware, and data to enable them to access their study material online. Educators and students basically had to quantum leap totally into remote teaching and learning mode. They had to scan book chapters, articles, images, and other teaching material that they could access from personal or loaned copies that they had, and then upload them to password-protected e-learning platforms. They, of course, hit the copyright barrier. Since hard copies were not available to their students, they needed to use more material than usually allowed, for example, 2 or 3 chapters rather than 1, which the licenses for collecting societies don't allow. Alternatively, they had to use sections from ebooks. When some lecturers did apply for permission to use extracts from ebooks, the publishers and collecting society declined their requests, saying the licenses did not permit this. They also told them that their students would have to buy the ebooks, even though they had already purchased the hard copies, but they were stuck in their residence rooms. This obviously was not possible for the students. Ebook prices in South Africa are unaffordable for students. Some books are more expensive than in developed countries. Some publishers will only sell directly to students and lecturers, not to libraries, as was mentioned earlier. In general, digital and ebook licenses are restrictive and proved to be very problematic in the COVID lockdown. A few South African publishers have made some concessions to use their materials, but these were very limited. In some public libraries, librarians were not able to read books to school children in their usual face-to-face reading circles because of the lockdown. To offer this service, they wanted to read extracts of books on YouTube or social media platforms, but copyright got in the way. They were informed by the local collecting society that permission would be necessary and appropriate course copyright fees would apply. Save for finding money and getting permission or using alternative material, what were the librarians supposed to do? Ironically, it is the authors who were being prejudiced because of restrictive copyright laws, as these reading circles introduce and promote local and new authors to users who have not read their works before. The Copyright Amendment Bill was approved by Parliament in March 2019. It has fair use and appropriate exceptions and limitations for libraries, archives, museums, and galleries, as well as for education and research and for people with disabilities. It also gives authors and creators more control over their works and will enable them to get a better deal on royalties because collecting societies will be regulated. It brings the law into the 21st century and will enable South Africa to positively embrace the fourth industrial revolution. These limitations and exceptions would have been extremely helpful to all stakeholders in the COVID lockdown, but especially to the library and educational sector and for people with disabilities. Unfortunately, due to much pressure from the US, the EU, and international entertainment and publishing conglomerates, our president returned the bill to Parliament on the 16th of June, right in the middle of the lockdown. He referred all these helpful exceptions back for review on the basis that they may be found to be unconstitutional and in conflict with the Berne three-step test. He notably and unconventionally based his entire decision almost word for word on one submission from a senior counsel representing the Copyright Coalition of South Africa, which strongly opposes the bill. Many submissions and letters from international, regional, and local organizations and a senior counsel opinion to Parliament and the presidency in support of the bill were seemingly ignored by the president. One does have to question his motives, especially since all the exceptions for the educational and library sectors are legitimate exceptions already enjoyed in many developed countries in this world, around the world. They were drafted within the framework of our constitution, human rights conventions, the Farnham Copyright Commission Review, the Marrakesh Treaty, the Eiffel Model Copyright Law, as well as various assessment studies and research reports, WIPO studies and treaty proposals that South Africa strongly supported through the Africa Group. It also adopted various clauses from progressive copyright regimes around the world, including fair use from the US and a number of other countries that have fair use. Well, it is therefore crucial now that the Parliament addresses the constitutional concerns raised by the President expeditiously, astutely, and transparently, so that the bill can be finally enacted for the benefit of all South Africans. Thanks very much.
Well, thank you very much, Denise. And I just realized that I hadn't actually introduced you at the start of your session. So just for the benefit of the attendees and those who don't already know you, Denise is the scholarly and communication, and she works at the Wits University in South Africa, where she's the scholarly communications and copyright services officer. And Denise has been a tireless campaigner for copyright law reform in South Africa for many years. So thank you very much to Denise for that. So now I'm going to hand over to our next speaker, who is Camille Francoise. Camille is Policy and Research Officer at IFLA, the International Federation of Library Associations and Institutions. And Camille is going to give us then a little roundup of some other interesting developments or interesting initiatives from around the world. So Camille, the floor is yours.
Thank you very much, Teresa. So first of all, thank you for having IFA in this panel. And I would like especially to thank you, actually, Teresa, because with IFL, you've made two very useful big piece of blogs on COVID-19, and I think it has been very helpful for the library field. So since we are quite short in time, I will just go within the subject already. So I will talk about three cases, Australia, Hungary, and Japan, because they had three different approaches and friendly outcomes from an educational perspective. So Australia, so in August 2020, the Australian Ministry for Communication announced a new copyright reform linked to the COVID-19 pandemic. And I quote, they note the need for change has been further highlighted during the COVID-19, with school, universities, cultural institutions, and government moving more services online. So their aim was to provide a more flexible and adaptable framework that will better support the need of Australians to access content in an increasingly digital environment. So they actually developed significant amendments to the library and archive exception set out in the Copyright Act in '68. So just very quickly to provide you with a general information. So as I said, it's a modernization of the library exception, which includes how to allow material held in the collection of institutions to be made available online for browsing at least. Also amendments on the document delivery and inter-library loan exceptions. So to simplify off-site supply of unpublished and audiovisual material. And other exception also as the modernization of education exception to ensure that copyrighted materials can be used in the same way for online and home learning as in the classroom. So, so for the moment, this is still a process ongoing, so it's not really clear exactly the details that would be finalized within this reform, but we are hopeful that this would make a significant change. So that's the one thing. On Hungary, I think, Teresa, you already mentioned it. For the people that followed the previous discussion yesterday, we already discussed a bit the case of Hungary with their speedy implementation of the Article 5 of the EU-DSM copyright, the copyright reform in Europe. So I think it's important to say that in this context of the wider emergency response, like Hungary modified the existing educational exception to include digital uses. So while originally intended to be a temporary measure, the government subsequently decided to that some elements could be made permanent and with in the same time as doing the implementation of the Article 5 for the use of work for teaching activities. So we skip the details of the articles because I think I will be a bit short, but basically they are going to expand the scope of I mean, they did already extend the scope of existing exceptions of the Copyright Act, and they created it without additional cost barrier or technical barriers, so that such as allowing suitable licenses and override of to override the exception or compensation. So that's one thing. Obviously. I will skip as well the details of the articles, but they made it possible through the definition of concept of the secure electronic environment and also the extension of the exception for educational purposes, as I said, and additional changes. And when it comes to Japan, so this is still ongoing because the Ministry of Education in Japan started a month ago a consultation and a discussion on copyright law and necessary amendments that they would like to make about exception and limitation to copyright for libraries, especially related to digital materials. So the ministry has hosted this consultation with several feedbacks from different stakeholders and released a draft with the main issues related to the closure of the libraries during the pandemic. And they acknowledge that, and I quote, that they underline that there is a need for access to library materials through the internet because it has become more and more apparent in the pandemic. So the key points of it came with a package of amendments, but the key points are to simplify the access to out-of-print material, and to simplify, to facilitate the access for users while having the library building closure. Also the library material transmission services, so the document delivery system, to be able to also provide online access, and other related issues that they didn't for the moment detail, so I will just be able to name them. So the scope of libraries, handling the elementary, middle, and high school libraries, and also the definition of library material, so handling of material borrowed from the library, other libraries. So that's it for me. Thank you very much.
Okay, thank you very much, Camille. So we have some developments and some initiatives from other countries around the world, which I think helps to fit the the global picture. So I encourage you, if you have any questions, specific questions for our panelists, or any general questions or comments, I encourage you to put them into the Q&A or the chat, because I believe that I'm not sure. Yeah, I think the chat is open to everybody. If not, please, we're keeping an eye out on the Q&A. We do have one question already from Paul, one of our panelists, and I think I'm actually going to ask Luis to answer that question at the end of his presentation, because it fits very much with what Luis is going to say. So Luis is, we're very honored for Luis to be here. I think, Luis, this is your third session on at least your third session on the Global Congress, so you've been very busy over the last couple of days. Luis is the director of an NGO in Chile called Innovarte. He's a lawyer and former vice chair of the WIPO Standing Committee on Copyright and Related Rights, that's SCCR, which is basically the body that sets global copyright norms. And in 2004, while representing Chile at WIPO, Luis introduced the exceptions agenda at the SCCR, proposing a treaty for the benefit of libraries, education, and people with disabilities. And one of the outcomes of that initiative was the Marrakesh Treaty, adopted by member states in 2013 and now being implemented all around the world. So, Luis, you're going to talk to us a little bit about the international environment and what supports there might be, and then how we might be able to move forward after hearing all of these issues. So thanks, Luis.
Well, thank you very much. Thank you, Teresa, for your kind invitation. You really are doing a great job on promoting access and justice in copyright. So I take the opportunity to recognize it, Teresa. Thank you. Also, I would like to ask you to remind me when I have 3 minutes left. Otherwise, I might, overrun my time. Well, first, I will not go into the justification for the reforms that we need to do, because you have already explained it very well. I will just frame it as I have said before, that this is not an issue of access to knowledge or access to culture as it used to be. Now it's an issue of access to life, because how dangerous might be a book being shared by many hands in a pandemic era. So having libraries to move to digital and to allow a new frame of copyright for permitting digital lending and digital services is an essential matter for all countries and governments and people with the goodwill. Saying that, let's go to take a look of the international. And if you see internationally all the copyright laws around the world, you will realize that they are not the same. And the restrictions that affect a good library service on the digital environment, especially, might be different from one country to country. You might have some countries like in the US, where you will have fair use as a special exception that will allow them to do a lot of things that are not in other countries, and or in this same country there are some rights that are not recognized for authors. For example, the lending right, which is a right that is recognized in Europe. So it's and if you go see in other countries, you will see other differences. Like some countries don't have a lending right and don't have a lending exceptions for library. So some problems are very specific to each country. So at some point in the next steps, we will have to review exactly what is the problem in your specific country to solve it there, and not to be too concentrated in the problems of other countries, because that might, or those solutions that might not be applicable for your country. So, but the other thing that is important to keep in mind, that if you have a copyright law that doesn't help you, or is making a problem for access, is actually part your own fault, because the national law are not given by God, are given by politicians that are responding to different mandates from different stakeholders. So copyright law might be changed. And I thank the question of Paul, who asked me, those changes that you are talking about are all TRIPS compliance. So here goes my answer. Probably the lawyer of a right holder might think differently, but I'm sure that my answer is the right one. Well, the first thing is that not all countries have the same national law, and not all countries have the same international frame, because there are a number of international treaties that provide for copyright, and in some countries you will have a stronger copyright international regime than others. So for some countries, some treaties are a problem. For other countries, those treaties are not a problem. In my explanation, I will assume that you have the worst scenario of international law, where you have all those treaties that give a nightmare to any librarians. So, on what are those treaties? Those treaties are basically, the Berne Convention. Well, all have Berne Convention. You have TRIPS, the Agreement on Intellectual Property of the World Trade Organization, and other countries have, in addition, have the WIPO copyright treaties, and in addition to that, other countries might have free trade agreements. Okay, but the good news is that Berne is considered in all those agreements, and all those agreements, the next steps agreement cannot go beyond, cannot not conflict with the Berne Convention. So some essential principles in Berne are incorporated in all the other agreements. So you have some key exceptions, key provisions that allow flexibilities in Berne Convention. And in the case for what we are speaking, the most relevant will be Article 9 and Article 10. Article 9, that allows reproduction for general purpose, in Article 10, that provides uses not only limited to reproduction, for illustration for teaching. And that is a very wide exception that is not, in my judgment, subject to the three-step test, because has a special frame, which is or a standard, which is called fair practice. I will not stop here, because it's a matter for further discussion, probably in a different workshop. And in Berne, you also have what's called implied exceptions, who are not within the text, but for everyone is understood that they exist, which are minor exceptions for things that are not that big. You have translation exceptions, and you have a competition-based exception. So that's for Berne. And importantly, Berne is not a treaty that applies to digital. So the rights that are required by Berne are not meant to be required for digital, because the Berne Convention has a requirement of protection that is fixation. And when you move to digital, you are not anymore fixating, you are representing in numbers. So Berne was understood not to cover digital, and that's why expressly WIPO has a special treaty that was meant to include digital, that is the WIPO copyright treaties, which are the internet treaties. So the really hard standard for copyright is the WIPO copyright treaty that was, as I mentioned, meant to cover internet issues. But there you have in Article 10, who expresses what are the possible exceptions for the digital environment. The WIPO copyright treaties, Article 10 agreement statement, expressly says that countries might extend their, I will read it to make it more clear. This provision should be understood to permit contracting parties to devise new exceptions and limitations that are appropriated in the digital network environment. Therefore, it is very clear that the countries can and must adapt their exceptions to the digital environment, which they have not done, most of them, and that's why IFLA and AFL and other NGOs, we are working in WIPO to try to adapt those exceptions to the new world. In addition to this provision of WIPO, the WIPO copyright treaties, let's go to TRIPS. TRIPS, Paul, is fantastic because TRIPS has almost no copyright specific rights granted. It relies on the Berne Convention and also provides for a very wide variety of options for limiting those rights. And everybody knows about the three-step test, right? Which is in Article 13. You nod your head if you agree, right? You know. Okay, but what probably you don't know, a normal copyright lawyer that is looking only into national law will not know that there exists Article 44.2 of the TRIPS agreement, and the Article 44.2 says that despite whatever you are obliged under TRIPS to recognize rights, you are not obliged to enforce those rights. It's very weird, right? You say you recognize the right, but in case of the remedies, Article 442 says, in any cases, when a remedy are inconsistent with the agreement, members shall provide at least that somebody there is a declaratory judgment and adequate compensation. So, and this is something that US use a lot, because in the US, in case, even if you are found that you have an infringement of copyright or patent law, the judge might say, okay, you're right, you infringe the law, but I think that it's better that you continue your infringement, but you have to pay something. So this is a fast track compulsory licensing or limitations subject to remuneration. And so, and very few countries, actually, I only know about the US that uses this. So this is a completely unused flexibility to give a comfort to libraries. Also, Article the TRIPS has another fantastic article, which is Article 73, which is called the security exception. An article shall be construed to prevent a member taking any action which is considered necessary for the protection of its essential security interest. Take that. So it clearly, in a case of a pandemic, you might completely, decide whatever you need to decide, and that's why India and South Africa are proposing in the TRIPS Council a waiver, for IP with regard to the pandemic, including copyright and patent. So clearly there is a space for copyright reform. The problem is, as South Africa experienced, is not only an issue of whether you have the flexibility in international law. It's an issue of political power, and factual power playing the game. Therefore, we need, as a community, and I'm going to my recommendation. Teresa, give me 3 minutes before you kill me off. Okay, 2 minutes. Okay, I will leave I will go very fast. So we have 2 levels of engagement. One level of engagement is focusing on the pandemic, and the other level of engagement is for the long term. So in the case of the short term and using the pandemic, we clearly need to create political pressure on WIPO, the TRIPS Council, the World Health Organization, and UNESCO, asking for fast-track declarations to provide security to library services. And for the long run, we need to improve what we already have on WIPO as a proposal for libraries. I will share my screen to make sure that you can take a fast look on all the proposals. How do I do to share the screen? Oops.
There's a green button at the end, at the bottom of your screen, a green button, share screen. Luis, we can send the slide.
Okay. Okay. You're right. Okay, so I will read it very quickly. So the first recommendation in short term is a political declaration to ensure libraries can provide digital services on a pandemic in each country. So that means to ask your favorite congressman. Also, we need to have a declaration asking library digital services declared as an essential service on a pandemic. Third, in addition to that, we should work on reporting missing elements on the copyright exceptions for library services in each country, so we can tailor the reform, a specific reform in each country. Also, we should try to take the issue of library services and copyright as an issue of health, and therefore we should work towards declaration in the World Health Organization, in PAHO, and engage civil society working on access to medicines to also see this as a matter of health. And finally, we should try to craft a mobilization campaign, stressing the issue that digital lending saves lives and bad copyright kills. Oh, thank you. I stop here.
Well, thanks very much, Luis, and well done for doing such a great summary in a very quick time. I understand the pressure, but I think you've really brought everything together at the end there. So send me your slide, and we'll put it up. I'm guessing that the organisers will have that there'll be a space to put up presentations and slides. So we'll make sure that we can include it in there. I really appreciate those very kind of concrete ideas. And I think the idea that we have to look to different fora. So we go to, the different international organizations, WIPO, UNESCO, WTO, and the TRIPS Council, I think is very good. And I'm glad that you mentioned, I'm glad that you mentioned the external pressures and the political pressures, because I was going to, respectfully disagree with your assertion that if our copyright laws are not working for libraries, that it's our fault. Because we try, as a library community, we try real hard to get copyright reforms, and sometimes it's very difficult. And I think the case of South Africa is a kind of a very obvious public example, and a very maybe extreme example where you had like the EU and the US really hammering on the government. But we see it in all different ways in all different countries. So you're quite right that it isn't just an issue of flexibilities in the treaties, but it's also an issue of political power and pressure and lobbying. And I suppose we need to strengthen our messages that we are acting in the public interest and in the interest of education. And we also have rights. So I thought the approach from Communia, for example, to focus on looking at the area of fundamental rights and how we can balance those rights to education and research with the rights, the exclusive copyrights. So I know that we're coming very close to the end of our session. I've been keeping an eye on the Q&A. We don't have any other live questions. So I'll just give one last opportunity for questions or comments from any of the speakers. Diego, how much time do we have left? Maybe you can tell us, or are we up against, are we there?
It's not. Teresa, may I make a brief comment? Something that I didn't say in the list of things. The other thing that we need to do is to build, a relationship with authors, because this cannot be seen as against the authors. It's against to abuse. So I think it will be very helpful if we try to make a dialogue with authors on fairness, because probably we could help them with things that abuse them, which are completely unacceptable. So they don't see libraries as the problem. I see the problem is other things for them. So if we have a conversation with them, excluding the intermediary, and then go including friendly intermediaries. So that's my point.
Yeah, thank you. That's a very good point. And of course, we do very much wish to work together with authors. And I was interested in the comments that from Caroline and Paul that that it's also working together with the academics and the professors in your institutions who very often are the authors of these the academic textbooks as well. So that's another point well taken. So guys, I think we are really right up to the end of our session. Diego is sending me messages, and yeah, so here we are. So we're going to end the session now. Thanks so much to all of you for listening in. Thank you very much to our panelists, presenters. Thank you to the interpreters who have been interpreting our session. And I hope it's given you some good ideas and some food for thought. And we will end it there. Thank you very much. Bye.
Thank you.
Thank you.
Bye.
Bye-bye, everyone.